tends to do in the afternoon, but it's okay. You're going to have a treat today because immigration is obviously very important to our practice and impacts people's lives. And we have to advise our clients about the immigration consequences of their pleas. To this end, in terms of educating us about the law and what we need to be thinking about, Raed Gonzales is here, and we very much appreciate him being here. He has an immigration practice and has a great presentation on the interplay between criminal law and immigration law. We've anticipated that there's going to be a number of questions, and we've built in time towards the end of this hour for those questions. So save up the questions till the end, and they will be answered. So without further ado, Mr. Gonzales.
Thank you.
Well, hello. My name is Raed Gonzales, as you said. I am from Puerto Rico. I do have an accent, so I apologize for that ahead of time. Is this on? Can you hear me? Merry Christmas. Hello, hello. You have to do something to it?
How about now?
Merry Christmas. Hello. Nope. 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 I can do it loudly.
This worked earlier. We're going to be all right. Yeah, we're going to be wrong.
Okay, talk
Nothing. Hello, hello, hello. Here we go, here we go. Okay. As I was saying, I am Puerto Rican. I do have an accent, so I'm going to apologize for that. So if you don't understand something, it's the accent, not my English. I'm going to give you a general presentation about immigration, just for you guys to have an idea of how this works out. There's going to be questions you can always ask us. There's nothing better than having an immigration lawyer as your best friend to help you, especially with cases that involve aliens and individuals who are already admitted as legal permanent residents and get involved with criminal offenses. I'm going to start giving you a very broad overview. And you know that ICE is the new agency that was created after the old INS was divided. And they created Department of Homeland Security, Customs and Border Patrol, and ICE. ICE is Immigration and Customs Enforcement, and they have the duty to actually investigate illegal entries in the United States, investigate the overstays, who's here illegally. And individuals, they're the ones in charge of placing individuals in removal proceedings. And in removal proceedings, there's a judge that is going to make a determination of if they're admissible into the country or if they're deportable. There's such a thing as some individuals can be one and not the other. Deportable is for the individuals that are already inside of the United States. They have been admitted for some reason or are here illegally. And some are inadmissible because they're coming into the country and they're seeking admission. There's some reasons why we deny entry to some individuals. And when you show up to a port of entry or at an airport, actually you're making an application to enter into the country. And a legal permanent resident that is coming from abroad is also seeking admission. And if somebody's applying to become a legal permanent resident within the agency as well as seeking admission into the United States, then there's deportable grounds for people that have been legally admitted into the country, and those who have been admitted or paroled but for some reason have violated their status and can be deported from the country. The most important aspect that is relevant to you guys is obviously the criminal grounds of inadmissibility. Anybody is actually subject to removal for the conviction of an aggravated felony, crimes involving moral turpitude with some exceptions, 2 or more of those, a controlled substance conviction, firearms offenses, and crimes of domestic violence, among others. The bad thing about aggravated felonies is that it limits the remedies and reliefs that we have in immigration court for individuals. They don't require an actual conviction if the person admits to the elements during an interview with a deportation officer or before any ICE officer. Actually, it is the equivalent of having been convicted. It can be an attempt or conspiracy of the crime, and both have the same consequences. And there's the one that drives us crazy from you guys when some people don't understand that some offenses, even though they're misdemeanors, can actually be considered aggravated felonies because of the sentence. And I'm going to give you the perfect example of theft. If you get a deferred conviction, deferred for a year for an individual, well, the Immigration and Nationality Act has its own definition of what a conviction is. And it says somewhere that if there has been some finding of guilt, and usually on a deferred adjudication, there is a finding of guilt, and the judge actually says, well, if you behave during all this time, then I'm going to dismiss it. The immigration statute says that if there's some type of punishment, the probation, it is a conviction for immigration purposes. Now, there's a difference. Again, there's no imposition of a sentence in a deferred adjudication. But if somebody pleads to, let's say, they offer him a year in prison, probated to 1 year. Well, under the immigration laws, it has become already an aggravated felony at that point. So it is easy to avoid in those cases if you can negotiate a plea of 12 months instead of saying a year, because that would be 360 days, and it would not meet the definition of aggravated felony within the immigration laws. There's no relief, for example, for legal permanent residents with aggravated felony. There's nothing they can do. They're going to be deported from the country. And more importantly, there's no bond. We cannot get them out on bond. So there's some aggravated felonies that are for crimes of violence, and it can be felonies or misdemeanors. It goes with the federal definition of what a crime of violence is. Obviously murder, obviously drug trafficking, any type of theft or burglary. Yes?
Could you go back to that last slide real quick? I don't understand if you're saying that if it's a deferred conviction.
For immigration purposes.
Right.
Even though an employer cannot see it or
Right.
there's nothing in the record, yes.
What I'm asking you is, you just said about 12 months versus a year.
Yes,
So if it's,
to jail and then probated.
right, if it's a, social family member case and he pleads to a year, in the judgment, we have to try to negotiate something that says 360 days instead of 365 days?
There is a lot of dilemma with the assaults right now, because usually an assault is a misdemeanor, correct? Okay, it's not, it's being fought right now in the Fifth Circuit. We're going to have something soon. There's some courts that say that it's not a crime of violence. There's some courts that are saying that it is. There's a stupid case from California, from the Ninth Circuit, where they found, it's a Board of Immigration Appeals case called Matter of Tran. And in that case, it was a simple assault, but the statute in California actually says that if you're hurting a spouse or a family member and you cause a traumatic injury, as slight as, I don't know, as doing this in her hand, but it causes a trauma, then it's going to be considered a crime involving moral turpitude or a crime of violence, depending on the sentence. But in Texas,
Let's forget that it's an assault case.
okay,
Anything else that's up to a year in jail. What I'm asking you is, do we need to try, like we have to
12 months instead of a year,
365 days, if we do
364.
32 grams of weed instead of 2 ounces?
The problem with the drug convictions also, we're going to talk about it later, is there's only one exception for 30 grams, not ounces, of marijuana. So that would help. But in the case of the assault, now that I brought it up, it's still being debated in the courts, but it will be considered a misdemeanor. Some judges consider it a crime of violence, some judges don't. But it's really funny also because there's an exception to all the rules that if there's any crime that involves moral turpitude, that the sentence, the maximum sentence can be 1 year. But you're sentenced to less than 6 months, you don't need a waiver for it. And you're not really deportable for it, and it's okay. It's considered a petty offense. But some judges are saying, no, it's a crime of violence because there was a use of force. So this is being debated right now. But as of negotiating a plea, I would definitely do less than a year so that they would not say that it's an aggravated felony.
So when you're saying sentence, you don't mean they're actually doing the 6 months in jail. You're saying if they sign for 6 months
If they do it, it won't affect them at that point, if it's only 6 months, as I said. But what we like is, again, what hits is the 365 days, okay? I mentioned the types of aggravated felonies, all firearms, failures to appear for service of sentence, any conviction related to failures to appear, rape, anything that involves sex and a minor is always considered an aggravated felony. Prostitution businesses, crimes related to commercial bribery, and obstruction of justice as well. Crime involving moral turpitude is, as I was saying with the assault statute, it's really complicated because there's not really a definition per se. Crimes are not really identified as crimes involving moral turpitude. So the Board of Immigration Appeals has says, well, their crimes are inherently base, vile, or depraved. But what is depraved for someone may not be depraved for somebody else. Let's take, for example, interference with a 911 call. Well, in the middle of an argument, I could have pushed you and I interfered with a call. It wasn't really intentional at that point. Some judges agree that it is a crime that involves moral turpitude. Some judges say that it's not. So it's good to study the court that you're in and what the opinion of the judge is in a particular case. But again, if you can plead something and you can get a sentence of less than a year, that is absolutely great. There's not an exhaustive list because, again, crimes are being created every day, and anything that involves something serious, kidnapping, arson, whether it's risks to somebody else, is going to be considered a crime that involves moral turpitude. So I mentioned earlier the petty offense exception. If it's a misdemeanor and the maximum sentence is 1 year and you're sentenced to less than 6, you're okay. There's not a pardon for it. Nevertheless, there's a problem for that one, for legal permanent residence, if it's committed within 5 years of admission, but we're going to get into that later on. There's another exception for youngsters who have committed an offense while under the age of 18, and they have only one, and when they're applying for admissions, more than 5 years have elapsed. All controlled substances convictions have immigration consequences. The only exception is that there is a pardon that you can ask if you're applying to become a legal permanent resident, for example, for 30 grams of marijuana or less. And legal permanent residents are allowed to smoke pot. If it's an offense of less than 30 grams of marijuana, they're not deportable. If it's more than that, they are. Firearms offenses, believe it or not, and this is how funny the immigration law is not a reason why you cannot be admitted into the country, but it's a reason why you can be deported from the country if you have an offense that involves firearms. That was a mishap from Congress. Take domestic violence, and once again, it has to be a crime of violence, and it has to be a protected person, a family member. That's why we love when we get an assault conviction where there's no finding of family violence and it's not marked on the judgment. At least we have some arguments that it's a simple assault, there's no real serious injury, and that it should not be considered a crime involving moral turpitude. Violation of orders of protection, only if the violation of the order involved credible threats of violence, harassment, or bodily injury to the person. So if it's a trespassing to the house, I can't think of any other, but trespassing, for example, would not hit the definition of aggravated felony for violation of a protective order. Now, you can be subject to removal if you entered illegally at the country, once again, if you're asking for admission into the country. And for having committed a crime that involves moral turpitude, any type of controlled substance, money laundering, if you have 2 or more offenses, regardless of they involve moral turpitude or not, if the aggregate sentence is actually imposes 5 years or more. We had a recent case that we could not believe that the government actually placed this guy in proceedings. They were, Naima, do you remember what was the charge? The driving without a license? That he had 21 convictions? It's a legal permanent resident, I believe. I don't remember which county. And he had, I don't know how many convictions for driving without a license, and they were giving him 6 months at a time probation. And when you would add them all up, it was like 11 years or something like that. And they actually stopped him coming from Mexico at the airport, and they told him, you're inadmissible. And instead of really, I'm sorry? He actually was from Arkansas. And this individual, they stopped him, and when you're coming into the country, if you're inadmissible, there's no bond. And you have to stay detained while your case is resolved. And you have read on the news how behind the immigration courts are. We're getting hearings for 2019 in some of the events. The courts for the detained individuals is a little faster, but it can be months as well. So they're really wasting our time, our tax money, detaining this person in jail because he had driven without a license. And the immigration judge even almost killed the office of the chief counsel because it was ridiculous. He did not need to be detained. They actually should have let him out, even though he should have had applied for a pardon before the court. But he risked deportation precisely because of that. Trafficking in people, domestic violence, as I said, and any diplomats involved in serious criminal activity are included. ICE can actually parole you in. They can actually give you a conditional entry into the country instead of detaining you. They can also offer release with an ankle bracelet, or they can actually establish some type of a bond, even in cases where the law says that they're not entitled to a bond. Now the Obama administration has made some steps to guarantee the prosecutors to have prosecutorial discretion in some cases and decide which cases to really prosecute. And they have different levels on how they're going to do this and different priorities. The first one being the ones that are convicted of serious offenses. There's a second priority of immigration violators with less serious offenses. And the third priority would be the ones that have really good ties to the country and family members. So we've had some individuals right now that are being arrested by the police. Oh, you're an illegal alien. And they take him to INS. INS checks, oh, you're married to a U.S. citizen. Yes. You have U.S. citizen children. Yes. You pay your taxes. Yes. Go home. And they're releasing them.